criminal defense attorney Mark Garagos and former federal prosecutor Neama Rahmani. Great to have you both. Neama, you call this case a long guilty plea. So far, it's incredibly strong for the prosecution.
That's absolutely right. And we have the trifecta of evidence here. We saw the video evidence that shows someone matching Ibarra's description. We have the digital evidence, the cell site evidence, Ibarra's phone going to the home of the other University of Georgia student, and then following to the location where Laken's phone was, and then traveling together, both phones, to Ibarra's apartment, wherein Laken's phone is discarded. And then, of course, we have the forensic evidence, the blood, the DNA, the fingerprint on Ibarra's cell phone. So really, there's really no defense here. I know the defense is going to say that, Jose's brother and roommate, they were logged into Ibarra's phone, but it's not going to carry the day. I expect to have a guilty verdict in this case as early as tomorrow.
Mark, what, if any, defense can lawyers for Jose Ibarra mount?
Well, they're mounting it right now, but one of the telltale signs here is when they waived jury, we call that a slow plea. I mean, my father, who was my partner for many years, a former prosecutor, used to say, if I ever think about waiving jury, hit me between the eyes with a baseball bat. There's no way when you waive a jury as a defense lawyer in a serious case like this that you expect a not guilty. What you expect is something, or that you're not going to put it in an emotionally charged case in front of a jury who's going to want to jump over the bar at your client. So they're going to do what they did today, call somebody for the timeline. They're going to poke holes wherever they can. It's an uphill battle.
Neama, there is evidence. You mentioned the cell phone evidence, which is pretty strong because it shows both Ibarra's cell phone and Laken Riley's cell phone together at the same time at the time of her murder. But there is some evidence that the other Ibarra brothers, who are all living with Jose Ibarra, also used that phone. Could the defense try to implicate one of the brothers instead?
They are, and obviously there's the evidence of Laken's smartwatch, which also showed her heart stop beating. But that's where the prosecution got ahead of this, and they showed the video, essentially, of Ibarra's brother's alibi, that he was working at the time on the University of Georgia campus, I believe, at the cafeteria. So he couldn't have been at the scene of the murder at the time. So prosecution did a good job anticipating that. Defense got out ahead of it. So I don't think the defense is going to have much of a shot in this case.
Okay, Mark, I just want to pivot now to another case in which you're involved, that one involving Eric and Lyle Menendez and their efforts for a resentencing. You're representing the brothers. California Governor Gavin Newsom now says he will defer any decision on whether to grant the brothers clemency to allow the new incoming LA County District Attorney to review the case. Nathan Hochman, that DA, was on this show last week, and he spoke to me about his plans to review it. Take a listen.
If it is on my docket, I would do the hard work as expeditiously as possible to either be ready on December 11th, or if I have to ask for additional time, ask for the minimum amount of additional time necessary to do this review.
Mark, he's not promising anything, just that he'll take a really good, long, close look at it. How hopeful are you that Hochman will do what George Gascon had pledged to do, which is get the brothers out early?
Well, I don't know that I'm hopeful or not hopeful. I've looked at what's called the C files, which are very extensive 30-year reflections of what's happened while they've been in the Department of Corrections. I have taken a look at the law. The incoming DA doesn't take office until after our hearing next Monday. The hearing next Monday, by all accounts, is going forward. It's a status conference, but I expect the 11th will go forward as well, absent some change. But the law is clear. Once the DA initiates a resentencing, a subsequent DA cannot do anything about that. And the DA has already initiated the resentencing. It's now in the hands of the judge. So we plan on going forward with the hearing.
And do you think you will prevail? That the judge will rule in your favor?
I have all the confidence in the world in this judge, and that he'll do the right thing. And the right thing here is to resentence them. The one thing that I'm asking for that the DA has not stipulated to, but I don't think opposes, is I want the judge to recall the murder conviction, sentence them to a manslaughter, and give them time served. That's the ultimate goal here.
All right. We will see what happens. Mark Aragos, Neama Rahmani, thank you both so much for being with us tonight. Really appreciate it.